Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
On 13 December, the European Commission finally adopted their draft adequacy decision on the long-awaited replacement of the Privacy Shield, the EU-US Data Privacy Framework, or commonly known by listeners of Serious Privacy as the Thingy. Kay and I have not had the full time to read all of the 134 pages, but we've skimmed through it. And in this episode of Serious Privacy, we start with our review of what is supposed to become the new adequacy decision for EU-US data transfers. Of course, it will still take quite a couple of months before the framework can be fully applicable, because it first needs to be reviewed by the European Data Protection Board and by the member states and the European Parliament, and then maybe renegotiated a little bit. But it seems that there is some light at the end of the long, dark tunnel that was the annulment of Privacy Shield 1. So without further ado, my name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So, Paul, yes, this is our next to the last episode, and we have some... Here's the thing. We went most of the year without hardly any world-altering privacy developments, and now everything's bam, 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 lined up before the new year comes in. So,
Of course,
this is going to be interesting.
That's how 2022 works. Shows off as a difficult year, then suddenly it becomes normal, and at the end it says, oh no, I was difficult after all.
Well, I have decided that my philosophy towards 2023 is we're all just going to not talk about it. I posted this on LinkedIn, but we were all hoping 2022 was going to be this fabulous year and we're ready for a normal year and let's get back to life. And yeah, we all saw how that went. So I'm deciding we're going to treat 2023. I can't even say that. We're going to act like 2023 is like a wild animal. We're going to walk softly. We're going to talk softly. We're not going to look it in the eyes. We're just going to hope it just kind of comes in and does its thing. And when it's over, we can all go, oh my gosh, that was fabulous. But anyway, so unexpected question. I'm not doing random because I don't have my book in front of me because I'm sitting in a hotel room in Florida right now, ready to jump on a ship. Let's see. Oh, what's your favorite Christmas song?
That's the Christmas song.
Oh, the Christmas song.
The Christmas song. The chestnuts roasting on an open fire. Jack Frost their nose.
Yes.
I love that song. And there are many versions, but yeah. That for me really evokes the spirit of Christmas and the weather that you would be hoping for, and cold and snowy and freezing, and the family all around. And yeah, I think that's the one. Number 2, probably Let It Snow.
Let It Snow. I like it. I was going to say now
the weather outside is frightful,
but the fire is so delightful. That one's been sticking in my head for days. I will say that.
Oh, yeah. For me, too.
Yeah. It just, I don't know that I've heard it anywhere. I've not really gone anywhere to hear Christmas music, but that one's been in my head. I've even been singing it quietly, but moving my mouth. And so my husband just looks at me and is like, what are you doing? I'm like, singing songs at a volume that most people can appreciate, which is nothing. But, I will say that when I was in high school, I took Rudolph the Red-Nosed Reindeer and I turned it into something else.
Mm-hmm.
And it was Randolph the Gold-Toothed Playboy. And
there was a boy called Randolph in your class, I guess?
No, it was fun. It was Randolph the Gold-Toothed Playboy. Anyway,
yada,
it was
yada,
funny.
yada.
Yeah, yada, yada. And it was funny. And I actually have a video of me singing it to my youngest daughter long before she even knows what words are.
And we'll put that in the show notes, ?
Oh, what the heck? It's like she remembers and I can't find the tape. So it was back on the old VHS tapes. Anyway, but it was so cute. I was holding her in my arms and I was softly crooning to her about this Playboy. But anyway, so yeah, I win Mother of the Year that year. But we have a lot to talk about.
One more question on this. Do you have in the US a thing called Whamageddon?
Yes, I think if you're talking about the whamming someone with the whatever song. No.
It's Last Christmas from Wham, and that you should try to avoid to hear it as long as possible until the run up of Christmas.
Until you just put that in my head and that's the only thing going on.
Don't sing it, because for a lot of people, at least here in the Netherlands, I'm not even sure about other countries, but this is a thing. This is a big thing. And people try to surprise each other, of course, in a mean way, by suddenly playing it or putting it in a card or putting it into a random clip that they send you.
Oh, yes. We do the same thing with songs by this particular singer. And it's like, got it. Okay. So I should never say Last Christmas. No, I can't even sing. That didn't even evoke the song. So yeah, we're leaving that one alone. We're going to pretend like I can
sing.
This
doesn't count.
It doesn't count, only if you hear it in your head, but I'm sure my vocalization drove it out and replaced it with something that doesn't even resemble the song. Okay, so for Christmas, it looks like the European Union is giving us some wonderful little treats here.
Well, at least 34 pages of reading materials.
Have you made it through all 134?
No, I have not. Because I also have work to do. And this is no longer my core work. I mean, while I was with TrustTech, this was my core work, and I could just spend a full day reading this and analyzing, and now I need to do it in my free time. And I haven't managed to get through it all.
That breaks my heart too. That breaks my heart too. It's for so many years, that's what I lived and breathed, was understanding all the global laws and the implications. And I could spend my work hours analyzing things that had nothing to do with, I would say with my work, but you know what I mean? Like right now, being privacy officer or privacy counsel, this isn't my everyday work to completely understand what this is and the implications for all the customers out there. So that doesn't mean Paul and I are slacking off. It just means it takes extra effort.
And there is also still this 27th of December deadline looming, which also coincides with
for the standard contractual clauses.
Yes.
Exactly. We actually had, we've got people asking, well, are you changing your data protection agreements or data processing agreements? And I'm like, there's no driving need to make sure that certain things are enunciated that have changed recently, because there's a provision in there that you will follow the laws, including following the laws as they may be amended, which gives you a little bit of time. Now, it doesn't give you time for the standard contractual clauses. I get it. I'm talking about a DPA. And I'm like, if you write your DPAs correctly, then hopefully every little bitty change in the law that comes out, you're not going to have to completely redo your DPAs. You should be able to write them where they're somewhat dynamic. The standard contractual clause, if y'all haven't moved over to using one of the 4 modules for standard contractual clauses, you're out of time in about, I'm looking at my watch.
About 11 days.
Quickly.
Yeah.
Yes, quickly.
And then you have these huge US tech vendors that say, oh no, but you can just download our new DPA and they are in there by reference. And I say, no, I don't accept that, because they need to be duly executed. And then they tell us, no, we don't do that. So I'm off for a couple of days.
And you got no bargaining power. Yeah, you've got no bargaining power. No one has bargaining power when it comes to these, which is why I loved it when Shora Nass did her AAs on some of the big tech. That was nice.
Yeah. So we'll see how we end up there. Yeah, we've got 134 pages of adequacy decision for the thingy.
Any of our listeners who have read them? Okay.
I'm sure there are a few. And we also got some 40 pages from the OECD on government surveillance policy, recommendations on the way forward.
Also fabulous.
So yeah, that's I think that's my Christmas reading settled. But I did go through the adequacy decision as best as I could in the time available.
And
so I do have
what's your
some initial
thoughts?
views. That I'm disappointed.
Oh,
We
why?
spoke about the executive order before, and we at the time said, well, we had expectations also about the commercial clauses, that they would be significantly updated to deal with the 2022 world instead of the 2001 world when those principles were first drafted, because they have not changed much
Right.
from the original safe harbor. And they still haven't changed much from the original safe harbor. The IAPP did actually a very useful sentence-by-sentence comparison. And if you look at the changes that were made from the commercial clauses on the privacy shield to the commercial clauses of the DPF, they're almost identical. And
Yeah, I kind of picked up on that too.
that's I think that's disappointing after 2.5 years of negotiations. And I had hoped that also on the commercial side, we would see some improvement, maybe also some of the enforcement that the FTC has done over the years included in the commercial principles. But for example, also things about data portability, still not there. And even though that is in principle a direct relation with the data controller, there might be some support needed from the data processors. The automated
Yes,
decision-making.
agreed.
There is actually quite a lot said about automated decision-making. And basically the European Commission says, oh yeah, but it's not important because there are other ways that the US has arranged this. So we shouldn't be concerned about that. And there is still the dispersed oversight with mediation bodies and data protection authorities and commercial oversight. And I don't know. I'm not convinced there. There is no real detail on the transition and maybe additional requirements from Privacy Shield to the framework. We still don't have the details on the designations as a qualifying state for the whole oversight and redress process from the Department
Nope.
of Justice. And everything that's being said about bulk collection and proportionality is all a question of semantics. US says, oh no, we don't do bulk, but according to the interpretation of the EU court, what the US does will be bulk. So
Is bulk. Yeah.
it's likely, at least from the European perspective, it's bulk and thus inadmissible. I don't see how this will go through without objections from the data protection authorities.
Well, but there's also going to be objections from the private watchdogs like OIB, who has already said they're already ready to object.
Yeah. So what did you think?
So, Will, I have to admit, I skimmed it. So I made it through all 134 pages, but I basically stopped and skimmed it at the parts that caught my attention. And you've called out most of those parts. I will say that my general impression of it is they had a lot not to say in 134 pages. It
Like
was
what?
like, right. This was kind of back when, oh gosh, what was the other thing that they pulled out? And I was really expecting them to be very clear and to hammer down on the points. And it's like they danced up to the line and then they went, oh, there's a line. And they danced back. And I was sitting there going, but can't you step over the line? Can't you be very clear here? And I was once again disappointed with that. But I do intend to go back through the 134 pages. God, I don't even think I counted the pages. But I do intend to go back through them. And this, while I'm on the cruise, this is going to be part of my reading material and say, are there any things here to actually pick out? Now, the most important thing to realize here is, one, there's still not an agreement in principle.
No, because they agree on the broader context. We need to fix this, but again, the semantics.
Yeah, there's really not. And as you said, most of the principles didn't change, which I kind of feel a little bit like a hypocrite there because, as I said before, the principles weren't really that bad. It was the provisions that went with the principles that weren't there. It was the other things we needed. But the principle of fairness and data minimization and all of that, that's exactly
that's all
what
fine.
you want to have there.
Yeah, no, that's
It's the
also
other
there.
part.
I don't
It's
have
the reason why it
complaint.
was invalidated. Yeah, it was the reason it was invalidated that we need them to address.
Yeah, but I also think nobody has ever assessed in court the commercial clauses. And also when looking at the commercial clauses and comparing it, for example, with the standard contractual clauses, there is a mismatch. And it's just, they are not to the same standard. And
they're really not.
No, essentially
And if
equivalence
we're
is not
talking
just about government surveillance. It's also about the commercial clauses.
Exactly. Well, and as you and I discussed before, companies have now, and especially with this looming December 27th requirement to have SCCs in place, many companies have actually negotiated the heck out of data protection agreements or I keep calling them data protection agreements, data processing agreements. They've negotiated the heck out of them. You can't negotiate standard contractual clauses, but you can negotiate the heck out of the DPAs. And companies have done so. I mean, down to provisions that I think are absolutely ridiculous to include, to those that you absolutely, companies take a stance on and they're like, absolutely, we have to have this. Many of them are not taking an individualized approach. You should be doing, which is what the court said you needed to do, is with each processor, you take an individualized approach. What data does that processor have? What do they do with the data? What countries do they go to? We've argued incessantly ad nauseum about the fact that the data transfer impact assessments and how controllers want processors to just hand them the entire thing, but part of it depends on the work with the controller. What I'm leading up to here is I was disappointed. How do you expect companies to transition away from everything they've negotiated and done to these new principles when the principles don't cover what they need to be covered?
Mm-hmm.
That's where I go to.
No, it's true. And you mentioned the data protection impact assessment. I know this is supposed to be an adequacy decision, but because it is self-certification, you would expect also there some form of impact assessment to become mandatory.
Yes.
It is not.
Yes. Yeah. So, like I said, I was once again waiting with bated breath, turning purple, fuchsia actually, which is more my color, waiting on this. And true, it came out sooner than I thought it would. I was not expecting this at least until after the new year. So it was interesting that it came out, but even more interesting that it's not everything that we wanted it to be. And I'm confused as to why. They took 134 pages to not explain why.
No, I agree. The good thing is, I mean, if this all goes through for the companies that want to rely or that are going to rely upon the DPF,
which will be thousands.
The transition from Privacy Shield
to
the thing will be easy. I mean, that is also what we predicted. You basically, according to one of the provisions, Article 6E on page 14 of the commercial clauses, says you only need to update the reference in your privacy notice. And then you're done. And you need to refile with the Department of Commerce. Also,
which I get, they're trying to make sense. They're trying to make the transition easy. We've always anticipated that anything that came out was going to make it worthwhile for those companies who stayed part of the Privacy Shield, even though it can't be used as a data transfer mechanism. They stayed a part of it because they are committing to certain principles that are of oversight authority by the U.S. Federal Trade Commission, the Department of Transportation too, but who sees those? And so it makes it worthwhile for those companies who adhered to those principles waiting up to this. They don't have to file new, but seriously? Yeah.
Okay.
Is this because we're looking at this through a twisted lens and the fact that we really expect this to be something that can be globally serve as a global model? It can be globally adopted. It can serve as a global model. I get it. The thingy is only between the U.S. and the EU, but the underlying
and the UK and
principles of it, right. But from the U.S.
Yeah.
But I was
had higher
hoping
hopes
for something. Yeah.
I had higher hopes.
Who do I need to hunt down and kick? Because
I can give you some names, but I will do that offline because that makes it safer. I don't want retribution my way.
But I would have liked to be a fly on the wall to hear the conversations, because some of the people involved in this, you can only imagine, have very strong opinions on the protections that should be there.
Yeah, and well, as I said, I had higher hopes after the court striking it down twice. And yes, the court struck it down on the basis of the government surveillance. And as we discussed before, we have come a long way there. And I think
Yes.
really on the government surveillance part, Executive Order 14086 has really made a significant impact. It's
Yes.
a good improvement. I'm willing to give it the benefit of the doubt. I am not certain about the bulk collection, although the bulk collection in 14086 is much more targeted than any bulk collection being done by European intelligence services, with all the targeting criteria that are also listed. So
Yeah.
the executive order actually is not that bad. The redress and oversight mechanism, in my view, also is not all that bad. It is not a court with the full constitutional protection that you may want it to have. At the same time, I do think it qualifies as independent judicial oversight.
Yeah. And it is fully enforceable, and it would take an act of Congress to either get rid of it or add to it. So it is more than what a lot of Europeans thought it was when they first heard of it. And I know a lot have done much into it to realize it. Plus, people here have done a lot of educational outreach. And so that happens. So
and that's
it's not
actually
horrible.
shared by one of the more critical, cynical data protection commissioners, the one from Hamburg, who's
Oh, my
also
goodness,
willing to
right?
give it the benefit of the doubt. So, I mean, that is a good step in the right direction. But
Yep.
on the commercial side, I know it hasn't been challenged. Yeah, I mean, here I don't see the essential equivalence to the GDPR. And that was already a mistake in the Privacy Shield that was negotiated and could have been aligned with the GDPR back in 2016, which did not happen. And it still didn't happen.
Yep.
So if
Yep.
I were the data protection authorities, that would be my key focus in my criticism. So Helen, I
Yeah.
don't know if you're still listening.
Helen's been busy lately.
Well, she's going into her
Let's get-
final year, so
Yeah, she's been busy lately, and I have to admit that I really loved having her on the podcast when she was, because that was the first time I'd ever, quote, met her, and I was impressed. And she's got a lot of work in front of her. I know she faces a lot of criticism, but look at the amount of work that she does. Good Lord. Okay,
Absolutely.
so both of us have expressed our incredible disappointment with how far this decision does not go. What are the next steps, people? We're still looking at 6 months.
yeah, we are still looking at 6 months, and that is also no surprise because now all the documents have been released. So now the data protection authorities will need to set to work to analyze all of this, and they will also check it against the European essential guarantees when it comes to government surveillance. I think that part has already begun, and now they will also need to assess the commercial side and all of the other points and see whether it meets their expectations.
Yeah.
That will likely take until the February plenary of the that will likely take until the February plenary of the European Data Protection Board, when they hopefully will be able to adopt an opinion. The European Parliament will need to give an opinion, and also the EU member states will give an opinion.
And I
then
don't
we'll
expect
see
all
what
those
the Commission
opinions
will
to be
do with it.
positive.
No, I don't.
Yeah.
But then we need to see what the European Commission will do with that, and quite possibly they will need to go back to the US and say, hey, we need to have another round of negotiation. And then
Right.
it needs to come, and it might need to come back for a follow-up advice, or at least the data protection authorities may want to give a follow-up advice before the Commission takes a final decision. So the Commissioner for Justice, Didier Reynders, has said he aims for a June decision, and then it's wait and see. And then immediately after the decision, it can go live. And that also means that by then we need to have the clarity from the Department of Justice on the designation of qualifying state. And
Right.
I had hoped that to be here sooner, actually, so that, as alleged, also all the other frameworks would be able to already rely upon these new safeguards in the executive order, like the standard contractual clauses. It would have been really helpful if the Department of Justice had made sure that before the 27th of December, the designation was already in place to at least make
Yeah.
all the transfer risk assessments a lot easier. But I guess that's not going to happen.
Yeah. This is an interesting world that we live in. I mean, I get it. Our podcast is dedicated to those that live in our world. But yesterday I was talking to the Lyft driver about this. And, when you mention privacy now in the U.S., and this has changed over the past few years, people assume that you handle privacy lawsuits. I'm like, no, not this chick. That's not where I go. I handle companies and their need to be compliant. And as I pointed out, when a company has a data breach, you often hear of their CEO being terminated or CISO, or may be face criminal penalties even. And, but you never hear of the CPO being terminated mostly it's because they didn't do what we told them to do anyway. So I get it. We're preaching to the choir here. Everybody gets this, but this is bringing a new element of complexity to what it is that we do. Ensuring privacy protections has never been complex. It hasn't been complicated. It's been very simple. You only collect the data you need. You only keep it for when you need it. You don't use it for any other purpose. You get rid of it when you no longer need it. You tell people what it is you're doing and you do what you do. You say what you do and you do what you say. Very simple. It's starting to get a lot more complex now. I mean, we wanted there to be more regulations and more government oversight, more enforcement that companies were actually doing this. They're not making it easier. They're actually making it harder, which doesn't mean get rid of it. What it means is y'all need to come together with a meeting of the minds and y'all need to do what needs to happen, because unless the government says to do it, companies aren't going to do it. And I get there's a huge cultural divide on privacy and data protection, which, by the way, I loved. Was it Ralph's explanation on the difference between privacy and data protection for people, which I was going to ask you to just explain that quickly. I know you've done it a time or two as well, but wanted you to speak to that. But I know there's this vast cultural difference between the U.S. and every other country that has privacy laws. Vast divide. And that the U.S. tech companies are the ones that, I guess, for lack of a better phrase, run the world.
Yeah.
Who doesn't have Google or Facebook or LinkedIn or Microsoft or Salesforce or any of these other huge companies out there?
If you don't have them directly, they are one layer down because your service providers will use them.
Exactly. Or Amazon. Yeah, let's throw Amazon in there too. So, I get it. But good Lord, can't they make this a little better? I think you and I have talked about this before. We don't need job security anymore.
No, we don't.
We just need the government to do what they're supposed to do, because companies aren't going to do it there is no self-regulation here.
No, and that's also a conversation. Actually, earlier this week when traveling to Switzerland, I was waiting for a train somewhere in Germany, and I ran into one of the Dutch members of the European Parliament who was on her way to Strasbourg, and I knew her from the days when I was working in the Senate, and it was a nice moment to catch up while both waiting on the train. And I won't go into all the details, but one of the things that we concluded is that also our governments are still so reluctant to accept the jurisdictions of the courts that they've created themselves. For example, when it comes to mass surveillance, where the courts have now said, probably about 24 times, dear governments, you cannot do this. You cannot do massive and indiscriminate data collection in the European Union or when you are subject to the European Convention of Human Rights, because it is not in line with our fundamental rights that you have created yourself. So also our governments still need a good lesson there.
Yeah, you're making me think there's got to be something. I like to take things and change them to privacy. So you're making me think I do not like green eggs and ham. I do not like them. I am. I did actually do one for the 12 days of Christmas and what your vendor brings to you. I'll see if I can't find that and publish that too. But yeah.
So on the difference between privacy and data protection, privacy is the right to be left alone. And that is in all aspects of life. That is possibility that you can just hide behind your home front door if you have an off day and that you don't want to see everybody.
Yeah.
That people cannot just barge into your house or into your car, or the discussion we now have here in the Netherlands, just access your school locker.
Oh,
there
wow.
Are police raids all
We've
over
had that conversation
too.
here.
Yeah. We have police raids all over schools because they are looking for illegal fireworks that kids may have. And that
Oh,
is
my
also
goodness.
a violation of their privacy. But that has nothing to do with data protection. Data protection
That would be
is
the least of the
only-
things we'd hide in a locker here.
I think maybe here there are also other things they hide. I remember from my school days, in the run-up to school parties, there would also always be alcohol hiding in those lockers. But
Yeah.
for example,
Anyway,
so the that's privacy. That is also the right to lead your own life the way that you want to lead your life and make your own choices, make your own mistakes. Whereas data protection is much more about your data, basically about everything that you say, that you write, that people know about you. So everything that is revealing about who and what you are and how that should be protected.
well, and here in the U.S., it is, people still think of privacy that way. It's the privacy of your data. It's the privacy of not having your information known. But I do like the move towards adopting more of the data protection versus privacy concept.
It's not versus,
some ways.
it's and. It's two
Right,
different
exactly.
fundamental rights that build upon each other. And I think the distinction is important.
Yep.
Why, for example, I'm no longer drafting a privacy notice, but a data protection and privacy notice, because I want to make sure that the data protection element is the central feature.
I like that. I think I term mine, not the notice online I do have as a privacy notice because, hello, I'm in the U.S. But otherwise, I usually do consider it data protection and governance.
Yeah. So that's one of the many things that we could talk about this week.
Yes.
I haven't even looked at the OECD date on government surveillance. I think that's something that we'll discuss next season when we come back at the end of January, because there is a lot to say about that one as well. But it would be nice to see if we can get from the OECD to talk to us about that.
That would be good. That would be good. And I will say that here in the U.S., we do have some major changes coming. I want to make sure we don't gloss over those. Yes, we are all aware that the CPRA, the next iteration of the CCPA, is coming into force in January 1st. This is most notably two different things. One, it adds sharing to selling. So the whole conversation about the targeted behavioral advertising and the cookies and the trackers and everything. So it adds sharing. I am boiling this down to simplicity, people. Yes, I get all the nuances there, just saying that this is part of it. The other biggest part is that California no longer has the exemption for business to business data or for HR related data. So dependencies, applicants, retirees, everything like that. That exemption expired. California did not pass a new one. Now, I would put money that California is going to come out and add another exemption to it at some point. But right now, companies are really struggling with how do they get the HR data in there. And there's a lot of guidance out there about you have to state in your data protection, let's just call them DPAs, in your data processing agreements that you're not going to do this or 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 this to HR data. I'm not necessarily of the mind that you have to specify you're not going to do that to HR data, because many companies just agree not to do that to any data. And if HR data is no longer exempted, then it applies to HR data. Same for B2B data. Now, this is where you hear a lot of people in the U.S., frankly, not liking rolling in B2B data because in their mind, this isn't data that needs to be protected. But it is the name and the contact information of people you work with at vendors. It could be sole proprietors, which might mean that their employer identification number is actually their social security number. There are people who still do that. And so there is information you need to protect. And in the UK, an interesting, and I need to see if this is still true, but it was true back when I was working in the healthcare field, is that partnerships were still considered sole proprietors because they were not corporations. So therefore, you still had to protect the data of partnerships just like you would an independent doctor. So there's a lot of nuances there with that. That's apparently my nom du jour today is nuances. So there's a lot of nuances there. And that is coming up January 1st. Also, the Virginia Data Protection Act goes into effect January 1st. Then you
Yes.
have Colorado and Connecticut on July 1st, and you have Utah at the end of the year. So will there be other state laws that pass in 2023? I think it slowed down this year because there was the possibility that the federal government was going to pass something. And it probably came closer than it ever has before, but still not there. So
Close enough.
what do I think is going to
But
happen
we might
with
see it again
2023?
next year.
I think,
with
well, we
Pelosi
know
gone
we're
from
going
the
to see something
speakership.
proposed.
It's I'm curious. What
And now the
will,
Democrats have the Senate.
Yeah, they have the Senate and the Republicans have the House.
Yeah. So that's something to take into account. Yeah, we know we'll see something proposed because we've seen something proposed for the last God only knows how many years. But
That's right.
I don't know what we're going to see from the states. I mean, they held back last year. We'll see. We'll see what
We'll
happens.
see indeed. We'll also need to take a look at India, which has tabled a new data protection law.
Yes.
The previous one, which was close to adoption, was finally repealed, and there is a new one on the table right now. So that's another one we'll look into in more detail in 2023.
Yep.
But I think on
And
that
Canada.
note... Oh, Canada.
Oh, Canada.
But I think on that note, we are going to wish you a very Merry Christmas.
Yes.
Because this is our final episode before the holidays. We will be back with you just before the end of the year with our year overview and our predictions for
And our
2023.
favorites.
And our favorites.
I told you we're not going to predict anything for 2023. It's a wild year. Just shh.
Okay,
Shh,
Kay
no
will not be predicting for
expectations,
2023,
no
although she
predictions.
just did, but I might. And there will be one more episode coming from us to you. for
Keep me
Christmas, and
honest, Paul.
After that, as usual, we take a bit of a break throughout January and be back around Data Protection Day.
Privacy Day.
Thank you again for listening this year. It is really exciting. One of the updates we got in recent weeks, we went over 1,200 downloads in one single week, which is absolutely amazing. And you don't realize how much that means to us. So thank you very much. A very, very Merry Christmas or any other holiday that you might
Yes.
be celebrating in the next couple of weeks. And we look forward to speak to you just before the end of the year.
There we go. On that note, we didn't say all of our Twitter and our LinkedIn. Y'all know where to find us. And with that,
Goodbye.
bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.